back, everyone. We're going to, what we've done so far, because we were told to break at 11:30, which we did, and so we have had session 1 and part of session 2. The last part of session 2 is George Siddell, who's going to look at some tools and show you some tools that mediation advocates can use in preparing for mediation. And then we're going to move after about 15 minutes into session 3, where Dwight has prepared some videos from a case study, and we're going to look at a few excerpts of those and think about what strategies and skills a mediation advisor or advocate might choose to use in those situations. So that's where we're going until 1 o'clock. All right? Happy? Excited? Yes. Here's George.
Can you hear me okay? Can you hear me okay? I'm loud enough. Sorry. Yes. Okay. So I'm about to say something and I have no idea what it means. 211 for 2. Does it mean anything to anybody? I've heard that's a cricket score. 211 for 2, right? Okay, so I just give you a quick update because I learned earlier about this. I learned earlier about the 3 C's, the court system, common law, and cricket being very important in India. Well, enjoyed the sessions this morning on cross-cultural negotiation. One thing that wasn't emphasized much was the question of how much do you adopt the style of the other side. And I think Echo, I don't know if she's here, she used the example of the Canadian who approached her mother-in-law with a hug. Well, there's another example a student of mine told me about a Japanese businessman approaching an American. And the question was, should you adopt the style of the other side? The Japanese businessman walked up to the American to give him a big hug, just as the American bowed. And so the Japanese businessman had an air hug and missed him completely. So that's another question to consider. So how many of you know the acronym MOOC? M-O-O-C, what that means. It stands for Massive Online Open Course. And it's been a big movement in education where universities are offering free online courses. I taught my first MOOC on dispute resolution and negotiation last fall, and I had 59,000 students from 198 countries. The United States was the #1 country with 24% of the students. Guess what was #2? China. No, not China. India, yes. India was #2 with 7% of the students. And the largest percentage of students were managers in companies. Guess what were #2, very close to managers? What profession? Lawyers, yes. Huge number of lawyers, many of whom were involved in mediation, many of whom were involved in dispute resolution centers, and there was tremendous interest in the course in a particular tool that I'm going to talk about this morning. This is an accordion session. I could make this 2 hours, or my boss Nadia gave me 15 minutes, so we're going to have the shorter version of the accordion. But it's something called decision tree analysis. So that's the tool we're going to look at, and the agenda, and like the other speakers, I'll move fairly quickly. I'm going to talk about some basic assumptions here, and then I'll describe how you create a decision tree. I was going to give you an exam, had we had time, where you could create your own decision tree, and that would determine who received a certificate or not. But we're not going to have the examination, therefore everyone receives a certificate. And then talk a little bit about using decision trees beyond mediation. And finally, if there's time, I'll mention one other tool, a life goals analysis that is a very useful tool. So let's get right into these assumptions. Assumption number 1, these are pretty clear to people in this group. Mediation is a type of negotiation. Oh, great, okay. And lawyers should prepare for mediation using the same tools they use when preparing for lawyer-to-lawyer settlement negotiations and other types of negotiation. So okay, next. So here's some examples of negotiation tools you should be using for deal-making negotiations or dispute resolution: planning checklists, style assessments, checklist of psychological tools, life goals analysis, and I am in the process of completing an app. I have the website up, and the mobile app should be done by the end of the month. But as a special exclusive for people in this conference, I'm going to give you an advanced look at this app. Just go to negotiationplanner.com. You'll see a list of 10 tools and other information. It's all free. I'm not selling anything. Okay? Here's an example of a negotiation style assessment developed by somebody many of you know, Jeswald Solacuse. It's a great practical tool for implementing cross-cultural issues of the type that were discussed earlier this morning. You can do a self-analysis with this, then analyze the other side, identify gaps in your style, and then focus on those gaps in preparing for negotiation. Here's a checklist of psychological tools. I won't go through that. I'll get to it later. Next. So our second assumption, although mediation is a negotiation, it's different from lawyer-to-lawyer settlement negotiations because you've got the active role of three additional parties, of course your client, the mediator, and the other side's client. Did we skip one? Okay, so because of these additional parties, the role of a lawyer in preparing for mediation and during the mediation becomes that of a teacher, where you're preparing your client for an active role in mediation. You're explaining your client's position and interest to the mediator during pre-mediation meetings, because I realize not everybody meets with mediators beforehand. It's common practice for some, uncommon for the others. And you must be a teacher when explaining the case to the other side's client. And this role can be challenging when there are language differences, and visualization can help. Part 4 of assumptions, your client's BATNA, your best alternative to a negotiated agreement, is especially important because your BATNA is your source of power in a negotiation. And in dispute resolution negotiations, your BATNA is often litigation or arbitration, and therefore one of your key teaching responsibilities is to explain this BATNA to your client and sometimes to the mediator and to the other side. This tool I'm going to refer to, the decision tree, is especially useful for analyzing, explaining, and visualizing the alternative to a mediated agreement. Decision trees can help your client understand the legal analysis. They can help you when you're communicating to the mediator and to the other side, especially useful when you have language barriers. And so I want to go through a three-step process. Before we get to that, one of the things I really enjoyed in looking at the course materials here is there's so much reference in these materials to BATNAs and the importance of BATNAs, and also to the importance of visualizing BATNAs. I don't know if you've had a chance to look through some of the materials, but just for example, in the AIM book of readings, they talk about the role of your role as an attorney in preparing the factual and legal analysis of the case and explaining that to your client, and then during the mediation, drawing the BATNA to help visualize what it looks like to the mediator and to the other side is recommended. So you're going to see lots of references to BATNAs in these materials. So let's take a look at this three-step process. This was a dispute. I helped someone in an intellectual property dispute. It was basically a $6 million IP dispute. And you start your decision tree process by drawing a picture that looks like a tree on its side. And the key elements here, the decision is represented by a square. In this case, the company I was working with, the plaintiff, was trying to decide whether to continue with litigation or settle. If they continued, then there were three legal uncertainties represented by circles. There was a software dispute. Was the software similar or not similar? Did the defendant have access to the software or not? and then there was a question of copyright validity. So you start by drawing a picture of the dispute, and even if you do nothing else, this is a very useful communication tool. I use it all the time in meetings, whether I'm dealing with legal issues or not. It just helps sort out the issues when people are going in 20 different directions. So even if you're not mathematically inclined, like me, it's a very useful tool, just if you stop right here. But second, yes. Second, you want to add numbers. Now, in this case, the attorneys had decided that there was a 60% chance that the plaintiff would prevail on the similarity issue, a 70% chance on the access issue, and an 80% chance on the copyright validity issue. And if they prevailed, they would win $6 million. If they lost on any of these issues, they would be out their legal expenses, which at the time of this case were estimated at $300,000. And they were considering a settlement offer of $1.5 million. Now, as attorneys, I think you can immediately guess where the problem is going to be when you start to use decision trees, and that's, are you willing to convert your probabilistic statements to numbers? There's a lot of resistance there. Okay, next. For example, in this case, the attorneys initially said, well, there's a better than even chance we're going to win on similarity issue. It is likely we're going to win on the access issue, and there's a high probability we're going to win on the copyright validity issue. What do those numbers mean to a group of lawyers? If I asked you what those numbers would mean, I would guess we'd have a wide range of probabilities. And if you ask your clients, what do those statements mean? Probably a huge range of probabilities. I ask students in my executive MBA class, who are mainly senior vice presidents of companies, what do these statements mean to you? Yes. And these are the results. Better than even. To some of these executives, better than even means 0. To some it means 99%. What does it is likely mean? To some executives it means 30%, to others 99%. High probability. Some means 25%, other 99%. Our method of communication is deeply flawed. It's a struggle to convert these to numbers. Lawyers are uncomfortable with that. There are tools like decision wheels that can help do that, but it's a struggle. Next. So then you basically do a little math, calculate weighted averages. 80% of 6 million plus 20% of 300 is 4.7. 70% of this plus 30% of this is 3.2. 60 of this plus 40 of minus 300 is 1.8. You calculate something called an expected value based on the weighted averages, and you can see here the expected value of the litigation is higher than the settlement offer. So if you used purely a decision tree analysis, which I'm not saying you should, this is a method of clarifying your thinking, but if you did use this, you would reject the settlement offer, which the client did in this case and won. Nadia, would you give me a 5 when I have 5 minutes left, or am I already there? I have 7 left? Oh, good. Oh, I was there 7. Oh, is that right? I'm over? I have 7 left. 7 left. Okay. Okay, so, next. Why don't you try a quick decision tree here? I think we do have time. So here's the deal. Your client claims that a custom rose $4.6 million. The customer says, well, the components your client supplied were defective. If the claim is litigated, there's a 50% chance you'll find email evidence resulting in a win for your client. If there's no evidence, you lose. If there is litigation, estimated legal and other expenses are $400,000 for both sides, for each side. And you're preparing your client for mediation. And one question is, what if the other side offers us $2 million? If you're doing a decision tree, would you, and you based your answer on the decision tree, would you accept that settlement offer or not? Now, you probably have an intuitive reaction here, which I hope is correct. But can you think of going through that 3-step process? Draw a picture of the decision, and then plug in the numbers, step number 2, and then calculate the weighted averages. In the interests of time, and because I want everyone here to earn the certificate, so we won't collect and grade your answers, Let's quickly go through what this would look like. This is the decision tree. Of course, this is a simpler version. It's a tree on its side. The decision is litigate or settle. And if you litigate, the uncertainty represented by the circle is we either win or lose, depending on the results of the email message. Plug in the numbers. Here it's pretty simple, 50% chance of winning. And if you win, you net 4.2 million after deducting legal expenses. If you lose your legal expenses for 400,000. And on the other hand, you have to decide whether to accept the settlement offer. And then finally, do the math, calculate weighted averages, 50% of 4.2 plus 50% of minus 200 results in an expected value of 1.9 million. Please tell me if my math is wrong. That's my weak part. But 1.9. And so if you made a decision solely on the basis of this decision tree, you would accept the settlement offer of 2 million. Okay, next. Now, when you do a decision tree analysis, you can bring into play certain psychological tools. A couple of these tools that I'm sure you're familiar with from negotiation in general. Anchoring is a very useful tool in developing a first offer strategy. Try to anchor the other side to your number. And also the importance of looking at negotiations from the other side's perspective. One of the interesting things here, yes, is if you do a decision tree from the perspective of the other side, their expected loss, it comes out to be 2.7 million. Your expected gain was 1.9 million. So if you can somehow anchor them on their loss, focusing on this is what you have to lose, do some reality testing in the words of mediation, this is what you have to use, then you have a stronger argument based on the decision tree. Okay, next. If you do end up in litigation, you can use decision trees for other uses. For example, a sensitivity analysis. I think it was Hal, I don't know if Hal's still here, but he talked about discovery costs in the United States. And when you do a sensitivity analysis, you can discover that, well, even if I uncover this evidence, it's not going to affect my decision. And so you can decide what issues to focus your discovery dollars on and when to skip. And also you can use this to calculate the maximum amount you would pay expert witnesses. Okay? But remember, this is really key. Decision analysis helps identify and sort out the issues in the case, but you're not committing to anything by doing the analysis. It's a tool. You probably don't want to rely on it in making your ultimate decision. So let me just go ahead to the last slide. Let me just close with this. Do I have 2 minutes? One, okay. Let me close quickly with this life goals analysis. This is another tool, but you often find that it's really your client who might be the problem. And so part of it is reality testing for your own client. And one of the tools in my new app is a life goals analysis to try to encourage your clients to think more of the big picture and not focus on the specific details of the dispute. I spoke at an ABA convention in San Francisco a couple years ago with a very prominent mediator named John Wade. I think some of you know him. And John gave this story, and I'll just close with this very quick story. We have a Chinese couple in Australia where John practiced mediation, involved in a very bitter divorce. The husband was a prominent doctor, prominent physician. He had a lot of assets. He was very popular in the Chinese community. His wife had very few friends. She tried to start a business. It was unsuccessful. She alone had very few assets. Bitter divorce. They divided up all of their property except for the last $40,000. They got down to the last $40,000 and they needed a mediator to decide. Well, and John Wade came in and he said to both of them, think of this in terms of the big picture. Think of it in terms of some of these life goals. The wife did that. The husband, the prominent physician, refused to do that. So eventually they ended up dividing the last $40,000. They go to court, they walk in, the husband is sitting on one side with all of his friends, the wife is sitting on the other side with just a couple of friends. The judge pronounces that, gives the judgment of divorce. The doctor and all of his friends go out of the courtroom. They're very jubilant, loud, happy. They go out, turn right to one of the fanciest restaurants in town. I think it was Melbourne. The wife walks out by herself, and as she walks out of the court, she turns to the husband's attorney, and she says, "Now it is time to get even." She walked out the court, she turned left, and she went down the street to the offices of the Medical Society. And she walked in and she said, "I would like to file a complaint against a physician. Number one, he committed an illegal abortion on me. Number two, he has been sending drugs illegally to his family back in China." She filed the complaint. The prominent physician lost his license, he lost his income, he lost his standing in the community, he lost everything. If he had thought of this in a bigger picture perspective, would he have fought right down to the end? So what I suggest, I think this is a very useful tool. When your client is the problem, try to get them to think in terms of a big picture perspective. And I'm now going to get, the hook has just arrived to yank me out of here. So thank you, Nadia.
Thank you very much, George. So technically, although we're doing this seamlessly, that's the end of session 2. Dwight is setting up the video, and he's going to introduce a case study for us. But I just wanted to, following on from what George was talking about, and I'm sure there is this software in a number of other places as well. I know from Australia, and George, I'm interested, because you were talking about your negotiation planning app. In Australia, there's software. There's a number of pieces of software. One is called Family Winner, and they've actually won innovation awards, not in the ADR industry, just general innovation awards. And they basically are artificial intelligence software systems that help you sort out your BATNA using searches of databases for cases and precedents and decision trees, using a combination. And legal aid in Australia, which pays for many mediations, use, for example, Family Winner, and all the mediation advocates, the lawyers involved, will have their alternative to a negotiated agreement generated for them, at least the basis for it, from this software. So I think there's a lot of, if your maths is not so good, try and find some software.
We're ready.
We're ready?
We're ready. I think we need Anil, though.
Anil.
Yes. So why don't you introduce it?
Now we're going to move to session 3, and Dwight is going to introduce a case study. Is that right, Dwight?
Yes. So we thought we would focus on 2 aspects of what happens in mediation. First, the opening session and the choices a lawyer can make around the opening session. And secondly, the problem of exchanging information and using a mediator to enhance your ability. But it's useful to look in a specific context. So let me introduce an actual case. It's the case, as some of you know who were there yesterday afternoon, that is on the flash drive that was distributed. The entire video is on the flash drive. You're welcome to use it. But it involves a dispute between Mumbai Partners and MedPro concerning the distribution of medical equipment in India, pulse oximeters. They plan on a long-term relationship, but they have a contract drafted by the Americans which allows either party to terminate at any time for cause, on 3 months' notice for no cause, and every year. Mumbai spends 2 years building a foundation, establishing contacts with hospitals in India, spending about $500,000 US. Sales grow rapidly from 0 up to 800,000, and then last year it's more difficult, and in May, MedPro sends a notice to Mumbai terminating the contract on 30 days' notice for poor sales. A few days later, the chief salesman for Mumbai resigns. sets up his own distributorship, and is given a franchise by MedPro. Mumbai alleged it's a theft. They obtain an Indian court order barring the salesman from selling, so now no one is selling oximeters. And Mumbai sues MedPro now in the United States courts, and our federal court sends them to mediation. So we thought it might be helpful to show you just 2 minutes of excerpts from the actual opening session, which is on your flash drive. It is only little bits, but it will give you a feel. And then we'd like to talk, perhaps Anil and Nadja will talk about what they might have done differently, because this is not about good advocacy, it is about mediation. The video. The video. Yes, and let me get through this. Well, give it 2 seconds, it will be through.
Well, thank you all for coming. It's delightful to meet all in the same room and finally move toward resolving the dispute. I'm going to turn the floor over to you.
There are really 2 layers of what's going on here. We have a sense of unfairness, and that is being betrayed, and we had an agreement and an understanding that we were going to have a long-term business relationship with MedPro. And that contract, in essence, was a handshake and an understanding, look somebody in the eye and make an arrangement. And we invested in that arrangement. And we were understanding that they were going to invest in that arrangement as well. And so my client put just a lot of energy and resources and time investing in that relationship and developing the market in India for MedPro.
Do you have anything you want to add?
Well, I mean, I think that is basically the case. I think what I would say is that, part of this is from the initial conversation that we had to start this contract, and Mr. Cooper was not there, and the entire meeting was about this being a long-term exclusive contract with Mumbai Partners, which means we would be the only company selling these oximeters in India. And in order to do something like that in India, you have to do a lot of initial work. I mean, basically, without us, there would be no Indian market for oximeters.
I look forward to hearing what you have to say. Obviously, we have a different perspective, and just want to outline that if I can. We had extraordinary hopes for the relationship between MedPro and Mumbai and for the sale of this really remarkable, innovative product in a country as large as India. And the bottom line is that those expectations were just gravely disappointed. I mean, this is about a business relationship. There were conversations and promises exchanged, but it was reduced to a contract.
I don't want to duplicate what my counsel has said, but the bottom line here is, we were trying to introduce ourselves to India through this product, and we have a lot more products that we want to introduce to India, and they're harming our ability to introduce ourselves to India. There's a real problem here. MedPro is interested in selling more product, so the idea that we would be consciously dampening our own sales doesn't make any sense. That hurts me when I go to my higher-ups.
So, 2.5 minutes, an American approach. Anil and Nadja, your comments.
Okay, so see here, we know mediators at the initial meeting does the homework for the attitudinal setting. But I would say the lawyers have an equal responsibility to prepare or to advance the attitudinal setting. See, it can be confrontational or it can be conciliatory. And here, if you look at the 2 lawyers, the lawyer of Mumbai and the lawyer of MedPro. See, the lawyer of Mumbai has in fact put up the facts in a non-accusatory manner so that things can only de-escalate from that position. But the MedPro lawyer has made an even stronger position, saying that, see, they came with so many hopes, but they couldn't perform or whatever. That particular accusatory note was there. And of course, the client intervened and made it soft. But the role of the lawyer would have been much better if the conciliatory tone, because see, when we are talking about a conciliatory tone, you have to clearly select the words, clearly select the subject that you're going to present, clearly select the timing where you're going to present the topics. So these three aspects, because you also have to show that when you're in a conciliatory note, you're not showing the sign of weakness. So these three things have to be prepared by the lawyer. In fact, the lawyer and the client should have a discussion as to what all things are they, what all words they are going to choose at the opening statement, what are the subjects they're going to disclose at the opening statement, and what is the timing that they're going to do for the opening statement. So I think if both the lawyers at the opening statement are in a confrontational attitude, I don't think the initial stage of settlement would happen. Because in fact, I would say every step or a mediation advocacy stage is like taking each step like a dance move. That is why Nadia is so effective as a mediator or a mediation lawyer.
Thank you. I love this dancing theme weaving its way throughout the entire conference. I think this, the opening is inextricably linked with your preparation as well, and with what the previous session has talked about. And I think as a mediation advisor, you need to be thinking of what representation model am I going to use with my client, and discuss that with the mediator, because the representation model that you use may be more effective if it mirrors the representation model on the other side as well. It depends. So in some cases, a mediation advisor may be involved the whole time but be absent from the mediation room, right? If you've got sophisticated clients, for example, that's not unusual. Or the mediation advisor may have more of a technically legal advisory role, or maybe a team player, and a negotiator, or maybe a spokesperson and actually do most of the speaking and most of the negotiating. There's an entire spectrum, and there are reasons and strategies why you would use a particular model. So I think we don't know whether they have whether this is a default position. The lawyer just starts. I thought it was interesting that the mediator asked the lawyers on both sides first, and then the client. You may choose to ask the client first. That would be my practice, and then ask the lawyer to add. But horses for courses. I think what I would always argue for is a planned strategy, not a default practice, right? So that you choose your model with your client in discussion with the mediator first. You direct your comments to the other side, which I think they largely did, because who's your audience? It's not the mediator, because the mediator is not a judge, right? Your audience is the other side. And I guess the question is, who's the decision maker, right? It's the client, technically. Is the client going to be heavily influenced by the lawyer? I mean, and focus your comments that way. If you're the second speaker, of course, I think it's always important not to respond too early, but to keep your own frame for your opening, to keep it informal, which they did, not to read, and I think it's hard to make a critical comment unless you particularly know what their strategy is. There might have been a reason why they opened relatively positionally, but I think you're right, Anil, it does limit what they can do afterwards.
No, they're just American lawyers. So I could offer a few comments, and then we would like to get your reactions for at least a few minutes. So I guess a couple of general comments and then more specifics. The general is